Lifu, a later translation of this court. The matter was assigned to me in 20 proceeded prior to the claimant. The fact that usable for the claimant are that the government in 1983 as an assistant lecturer, Advanced Teachers College, Oju, and his appointment in 1986, as he was promoted in 1980 of Kogi State. He was deployed to the continued to work until 2016 when he received a letter of dismissal from the defendant for misconduct and sexual harassment. The claimant claims that dismissal is unconstitutional, null and void. Case of the defendants. Conversely, the fact from the pleadings of the defendant on allegation of examination misconduct against the claimant was invited to an ethics committee of the defendant and given dismissed. The defendant did not the regulation and laws governing trial in November 2019, where the claimant testified as CW and adopted his statement on oath dated 2016 and tendered a total of 7 laws. Number 1, Alpha letter dated 14th September. Number 2, Alpha 2 confirmation of appointment dated 18/6. Number 3, Alpha 3 notification 17th October 1988. 4, Alpha 4 letter of dismissal dated 2015. Number A and B solicitors letter dated 26th July issued by solicitor dated 16. Number 6, Alpha College Education Regulation governing the conduct of November 2007. Number 7, Alpha 7 Academy Regulations examined by the Defense Council and was discharged after re-exam. On 28 January 2020, DW M. Agada, defendant by adopting a statement on oath dated 27 April 2017 and 4 exhibit as follows. SDOE Kogi State defendant. Number 2, appointment dated 4th January 2016. Report of investigation of the alleged involvement of the claimant in misconduct. Number 4, letter from defendant to the commission dated 2026. The defendant's cross-examination of PW1 as there was no. The matter was then adjourned 2020 for additional final written addresses. Defendant's submissions. Defendant's final written address is dated 10th file on 12 February 2020. Were published therein for determination to it. Number 1, was the claimant granted fair hearing before his dismissal from the defendant? Number 2, is it correct to defendant on sexual harassment by the claimant with Patrick is uncontroversial by the court as a correct position? Number 3, the claimant worthy of being granted, or whether the claimant has any cause of action against the first. Issue number 1, for the defendant submitted that the right of the claimant to be heard before any disciplinary against him, and the right to fair hearing before dismissal from his conduct and the rules of natural justice as identified by Lord Camp as the principle of eternal justice. Exhibit Rams, and in the case of Professor Du Olabuns, Nigerian Institute of Social Economic Research Council, still argued that the defendant had all principle of audi ultra partem, enshrined section 26(4) of the law established, and also in the regulation governing the conditions of service of The defendants, via the college, that the complaint against the claimant was properly investigated. The claimant was invited to defend himself as shown by 3 and 4A. So the first that Land Council that the claimant never had any for the Works and Ethics Committee. Now the claimant admitted his invitation and appeared before the state paragraphs 9 and 10 of his council rely on the authority of Friday Daniel Mwakudu. The council submitted that by authorities Akinolu and Nigerian Electricity Liability that once an employer affords an employee an opportunity to dismissal, then such an employee can no longer complain of as even an answer to a query by an employee. The court was urged by the landlord the claimant was heard before his dismissal. Number 2, another counsel submitted that in civil case, the duty of parties is to join issues on aspect of the pleadings in dispute. Failure to so join issues will amount to an admission. Also refer to the case of Madam Adami and Apostle and argue that the amendments in paragraphs 29 to 35 have not been controverted by the claimant. In the same argued that evidence to improve of these facts taken an unchallenged, and the court can attach with consulting the case of Jumo issue. Also, the evidence of sexual harassment is unchallenged. Said that the first relief, issue number 3, that counsel said that the first relief of the claim or lawful cannot be granted as the having followed all procedures of fair hearing. The second relief for reinstatement, counsel submitted that reinstating the claim aside the letter of dismissal and employed on an unwilling. Counsel started the case of Oyedele and Ife University Teaching Hospital Board. Died on the case of Warri Refining and Petrochemical Company Limited, Ongo, in defining what constitutes employment with the first submission of a counsel that the claim for specific damage pleaded and strictly proved as held in the case of Gonzi General Education Research and Development Council. Last senior advocate submitted on relief for general damages which by law follows a breach as held in the case of MTN Nigerian Communication Aquaculture Cooperative Farmer Society Limited. On the authorities in Guinness, Nigerian PLC and Mweke, counsel argued that it is an affront to public policy for a litigant to restore fees to the opponent. On issue number 4, Land Council submitted on this issue that the first upon unknown principle as acts done within the disclosed principle are acts of the principle. Defendant incurs no liability for acts within or apparent authority from his principal. Counsel rely on the case of Andy Sam Investment Company Limited. Counsel finally urged the court to dismiss the claim with punitive claimant's submission. Claimant's final written address was filed on wherein 2 issues were as follows. Number is entitled to reinstatement to office in his position in view of the dismissal of his appointment without regards to. Number 2, whether or not the claimant is entitled to be paid all his entitlement accruable to him from the date of his dismissal. On issue of a counsel that the claimant is entitled to be reinstated to the second defendant in view of his dismissal. argued that the claimant was dismissed in 2016 on grounds of sexual harassment. However, with any petition prior to the phone call by the officer to him, ethics committee, 2016, that the claimant was informed of the petition against N.A. Elizabeth. But the council argued that the Works and Ethics Committee had no powers to try or recommend the termination of his staff of the college, and since the claimant of the college is the only council that had the authority to terminate due process. 11.2 govern the conditions of service for staff exhibit. According to council, the provisions before the termination of the claimant's appointment, fair hearing was never afforded. So, on Bukavu and Kano Nature Authority, that in line with the provisions of the Exhibit 6, the defendant, the claimant notice of intention to terminate his appointment or dismissal, and not to dismiss him. Furthermore, council submitted that Exhibit 7 provides for scripts, but there is no complaint by the said Miss Elizabeth N.A. Patrick. Now, the allegations of sexual harassment and examination malpractice is but a setup. There was no complaint made against anyone on examination malpractice, and evidence of DW1 lends credence to this. And the council argued that the claimant was never invited to appear before a joint committee of the council and academic board to answer any of these allegations, issued any query to the claimant. Neither was the claimant issued any query in respect of these allegations. It's also a submission of a council that Exhibit Alpha 6 does not provide for the approval of dismissal of the senior staff of the council. Thus, the dismissal of the appointment of the claimant by the Commissioner of Education was in breach of Exhibit 6, the application of the law as the second defendant. Or they comply with the provisions of Section 01 and 11.03 of Exhibit 6. And the council submitted that the claimant deserves to be reinstated as his appointment was protected by statute. Council referred to the case of Udo and Cross River States Newspaper Corporation, Shita Bay and Public Service Commission. Permitting further, council relied on the case of Z-Day and River State CSC and AG Oyo State and Federal Civil Service and Lawe, that once fair hearing is not given an employee, is not given to an employee before termination or dismissal, such a decision of termination or termination is a nullity. Such a decision of termination or dismissal is a nullity. Council further submitted the allegation of sexual harassment is a crime under the penal code. It's only the court of law that can determine or otherwise of the claimant. So with Angoche and Civil Service Plateau State, University of Council side Exhibit 4A and order the statement of the on issue the submission of a council that the claimant is emoluments from the date of reinstatement. Council adopted his submission, first submit that in view of the course of action, all the reliefs sought. But when the claimant is reinstated, entitlements due to him are also to follow. Council considered that the case of D.O. Dr. Ben O. Chuk Chemical Company Limited cited by are not applicable. statement can be made. In the case of AV and Morrison Industries PLC, therefore, between the claimant and the second defendant was regulated by 6, settled with all emoluments paid to. Also rely on the case of Iguilo, Chitabi and Public Service Commission on the issue of damages in case of dismissal, SPDC Limited and Olariwaju. Council submitted that Gonzin and MS GB Nigeria Limited specific damages are not applicable to Council the court to resolve this issue in favor and sought by the claimant. After the party extend the final council on July 20, the preliminary objection challenging the jurisdiction of the preliminary objection replies to the notice of preliminary objection February 2020 on 24th March 2020. And a senior counsel directed one issue for termination in his notice of preliminary objection as follows: whether of paragraph 2.04 regulations covering the condition of cyber ANCPA Nigeria Exhibit 6 file the condition precedent to the filing of this submitted that the issue raised by the parties or sue more to proceedings. Also refer to the case of Corn Oil PLC Governing Council. Is a local government and Adedi Balogun. It was also submitted that before an employer court against the second defendant, must have first referred the case to the commission. Some case failed to do that. Throughout the length and breadth of the claimant's case, that reported his case to the public. And a council 0.06, which is follows. Without prejudice to the foregoing, you should take the college to court without first public complaint commission or resign his appointment. And a council argued that compliance with a stipulated precondition for process in motion is in contravention of the precondition, and the court lacks jurisdiction to entertain. Also refer to the case of Lagos and Sakamoni Construction Nigeria Limited, Texaco Panama, and Shell Petroleum Development Corporation of Nigeria. In the claimant's reply objection, counsel for the claimant submitted that the claimant's non-compliance with Chapter 11 of Exhibit Alpha 6 has the reason to entertain and hear this case. Also refer to Section 42 of the 1999 Constitution of the Federal Republic of Nigeria as amended to submit that the claimant has to seek for legal redress where his employment has been terminated. It is a contention of counsel that by virtue of Section 6A and B of the Constitution, as the judicial powers of this court extend between persons or between government person and to all action relating there of any question. To the Constitution of Land Council, by virtue of Section 6(6)(a) and (b) as amended, the judicial powers of this all matters between persons or between government and any person thereto for the determination of any question as civil rights and obligations of that person. Also argued that Chapter 11.04 of Exhibit Alpha is inconsistent with the provisions of the Constitution, hence the Constitution shall prevail. That other instrument shall be void to the extent of that inconsistency. Finally, urge the court to expunge Chapter 11.04 of the Defendant Governing Conditions of Service for staff members. The processes filed by the parties, the evidence adduced, and submission of the respective counsel. The defendant formulated 4 issues for determination, and the claimant raised 2 issues. On which I will decide this case is whether, by the evidence adduced before the court, establish his claims to be entitled to judgment. It's necessary to start off with a notice of preliminary objection filed by the defendant. The defendant pointed to Chapter 11.04 of the Second Defendant Regulation Governing Conditions of Service Post that the claimant has not complied with the provisions of the said Chapter 11.04. 11.04 states as follows. Number 8, and I quote, senior staff member may resign his appointment with the college by giving at the writing to a registrar through the appropriate head of department, or if paid in lieu of notice, unless otherwise agreed. Such notice shall, for teaching staff, expire. Staff are expected to give 1 month notice or pay the month salary in lieu of notice. A member of staff resigns his appointment by giving notice which expired less than 12 months after commencement of his appointment. He may, if considered necessary, be required to, in part or in full, transport expenses when he first took up appointment. Number C, without prejudice to the foregoing, no employee shall take court without first referring the case to the commission or resign his appointment. The law appears to be settled that statutes must be, and the words contained therein be given their ordinary meaning. Look at Chapter 11.04C of the Regulation of Service. It only means that where there is respect to an employee of the second defendant, the said employee case to the Public Complaint Commission, or else appointment. Provision of Chapter 11.4.04C, case of a dismissed staff as in the instance case. And I find it worrisome to observe that this suit was filed in 20 since extended pleadings and witnesses taken from both and their final return addresses already filed. However, it dawned on the defendants that the claimant has not complied with the precondition before the initiation of. I think that is too late in the day. The courts have from the narrow technical approach to justice, which bedeviled earlier decisions of courts, has now renewed vigor and stress on doing substantial justice. And to me, is what will be the justice in this case, in striking out this matter and the so-called internal mechanism, when parties have long obtained their final written addresses and proceedings have spanned about 5 years already. I will ignore what I view as a mere technicality in order to do substantial justice. Passenger Farms Nigeria Limited and Tijani Ado Muhammad, it was held that filing an unconditional appearance filing a statement of defense, or answer to a claim or anything done with effect of defending an action amounts to taking steps that will foreclose the right of a party to raise an issue of the provisions of the Sheriffs and Civil Process Act. Rather from the above, I note no reservation to resolution lacks merit and is hereby overruled. For substantive case, the claimant's case against the defendant as shown in the statement of facts are that he was a senior staff and lecturer, one in English department of the second defendant. Service of the Benue State government in 1993 as an assistant lecturer with the Advanced Teachers College, Oju, and his appointed in 1986. He was promoted in 1988 and upon creation of Kogi State, he was deployed to the second defendant and he continued to work when he received a letter of dismissal from the defendant on grounds of examination misconduct and the claimant's principal relieves that to declare his dismissal null and void, to reinstate him and pay his due from the date of his dismissal. To improve his case, the claimant tendered a total of 7 exhibits. The arguments of the claimant leading to dismissal was not in accordance with the provisions of exhibit Alpha 6 OE1 Kogi State College of Education Regulation governing the Commission of November 2007 and Kogi State Law College of Education ANCPA. He also argued that he was any alleged misconduct or issued a query before his dismissal, in violation of his right to fair hearing. Wrongful dismissal, the claimant owes the tax, the terms and conditions, and how they have been breached, and this is the case of an NNPC. Alpha 1 and 6, the contract of employment of the claimant. One is the appointment letter, one is govern the conditions of service for carefully peruse this exhibit, especially chapters Alpha 6, with the KSCOE1 and the claims of the claimant before this court. Chapter 11.0 Alpha 6 state as an officer shall not be terminated or dismissed. He or she is notified the right which the college proposed terminate duty to defend himself, except that any officer information, education, previous rank or out formalities. On chapter 0.02 of exhibit Alpha, as some of this defendant of misconduct, gross misconduct as defined there. Chapter 04 provides that if there are reasons for believing that any person employed as member of the administrative or technical staff, other than the provost office, misconduct or inability of his office, so shall take the following steps. Number A, give notice of opportunity of make person on the matter. If he of counsel so request of 1 month begin the notice, make arrangement. 1, if he's an academic or joint committee of the council, the academic board to investigate and to report on it court. Argued that he was never invited to the committee of the council and academic board of the allegation of misconduct and sexual harassment made by one Elizabeth Patrick. So that he only received a phone information of 13th April 2016 to an ethics committee of the secretary. It was when he got there, he was confronted with the allegations of conduct, examination misconduct, and sexual harassment. According to the claimant, he never appeared the petitioner to defend the harassment. That was by the Students' Welfare Committee, whom the defendant the petition to the Academic Stroke Ethics Committee. The defendant built their defense along the responded to the invitation stroke and stroke work to defend himself against allegation misconduct and party, which was made by the Students' Committee. The defendant fair hearing was to defend himself before his dismissal. The defendant tendered KSCO and 4A in exhibit report of investigation on the alleged involvement misconduct, harassment. The sexual harassment Elizabeth Patrick committee in its investigation video compact discs CD to ascertain the claim and of the claimant and Elizabeth, and she also stated 3 at paragraph 6.0 findings as follows. A court based on the by both parties recorded telephone conversation to the hearing of the committee members findings on court at paragraph 7.0 of the above exhibit. Recommendation of the committees and a court. Foregoing findings establish a case of sexual harassment. Mr. P.U. of English Department, according to chapter 12.0, the regulations governing the condition of service 7, and hereby recommend on court. The employment of the claimant will be affected by the terms and conditions of with 1, letter of appointment, Exhibit 6, regulations for staff members, and Exhibit KCOE1, a law establishing education. From the above exhibit before, the court is protected by statute, and while the control of statute or where the condition regulations drive actions, the employee with illegal status, one of master and servant. Only acceptable means of employment that enjoys flavor, musbau, adinwi, and in such and manner as prescribed by and any other system with the relevance is thus no effect. Less employment in the public, the federation, states, or local agencies of government, including institutions and the civil service or public service rule, or are made relevant to the case of Para and Shitu, Lauren and Abe. A public officer against whom an alleged conduct is laid without being heard. Where an investigative panel is set up, it's not proper for an employer on the basis of the report of an investigative panel only. Should take a step further by the panel to innocence of the employee. An employer must follow the procedure and where such and employees to be unoperative and see the case of FUT. In the case of the appointment of an employee on grounds, the employer needs to establish to justify is to show that close to the employee was given a fair hearing, that the Ministry of Justice were not breached. The panel followed the laid down procedure where the employee accepted the act after investigation. In this case, petition from the Student Welfare and Disciplinary Committee, which kickstarted disciplinary measures against the claimant before the Ethics Committee, also of the claimant. He was invited on phone officer to appear before the ethics. Claimant further testified that he was never video recording of the alleged sexual harassment, and that any underscored any exams could complain as provided in Alpha 7. Said that no time was taken for failing the state student or understand. Rather, was the one who apprehended the state, who confessed to have student for her. The blue one that during investigation and ethics committee by the petitioner Elizabeth and the claimant never, and that the state student did not confess, surely set up contrary to this piece of paragraph KSC, and I quote, set up Mr. P.U. Alpha up. She was caught, unquote. There was a set up a sexual harassment, malpractice or not. Whether dismissal of the claim was done in Exhibit Alpha 6, governing the condition of service. It's evident from before this court to show that claimant with the allegation accept an invitation by a before a committee set up by the college. This is what DW1 examination on 28th January 2020. I don't know if the claimant was, I don't know how the claimant was in committee, but I only know that she appeared on court. Paragraph 4 of Exhibit K.E.1 reads, and I quote, staff of the college shall be removed. He shall have been given an opportunity to make representations. Besides this, of the video CD before this, neither was the petitioner called to give evidence the veracity or otherwise of the findings claimant, especially when there's, though the law is the right to hire and fire, you must adhere to the terms of the contract. See the case of PPB. Furthermore, the cost a boy where an employer for terminating the employment of employee, the reasons thereof. Therefore, have the duty to substantiate gross misconduct and sexual, which are the basis for the dismissal of the. There must be evidence that the claim allegation of the petitioner, investigation of the students' welfare, which was sent to Works and Ethics Committee. The evidence that the claimant was confirmed of the petitioner and the of the Student Welfare and Disciplinary Committee to the academic and the academic ethics committee set up by complying with the provision of and exhibit OE1 as regard the procedural claimant. So OE Article 8 empower the Commissioner for Education in the state function of the council in the absence of the council. The procedure adopted in each case full of fair hearing. Based from the above state of fact that the claimant up to the provisions of exhibit alpha 1(6) C1. Not having failed to place before the video CD viewed the video CD ethics committee viewed his conclusion to dismiss the claimant and the failure to present the evidence Patrick the fact that the defendant have not successfully dismissing the claimant. Of the procedure of the investigative committee had any interface to get each other. He said that the most important aspect is that it must be according to rules. The employer is entitled to know against him in order to be able to his case. He should also to state his case no matter what the. It's not essential that he should be throughout the hearing. In TO and UC, I found that presented by the claimant have not been by the defendant. Arabambi and advanced level. Supreme Court has held that controversy is not successfully become controverted, credible, and rely on it. Sky Power Air Wesley. Therefore, uncontroverted or unchallenged can act on sin. From the above, claimant succeeds only in part, and I make the following order. Number one, at the data of this reference number RCOEA SP/CO exhibit alpha 4 unified and set aside. Number two, that the claimant dismissal from the site is unlawful. Number three, that the defendants are directed the claimant to his office and position. Number four, that the defendants are directed to pay all entitlements due and from the date of number four, and cost of this suit are here refused. Yes, Mr. Garba.
We are exceptionally grateful to the wisdom and the great judgment of this honorable court. Exceptionally grateful.
Osai.
My Lord, we are grateful for a well-considered judgment and the wisdom of the court. We are grateful, my Lord.
Thank you. You are going to get it from
Ascot, please.
From Makori Division.
Okay.
Yes, my Lord. I'm with POSI, my Lord. We are for the defendants.
Can you hear me?
Yes, my Lord.
The soft copy will be sent through while we get the hard copy division of the court.
As God please.
As God pleases.
So the other thing today.
Wow, network.
Me?
Hello, my Lord.
Hello, can you hear?
Yes, my Lord, network.
Okay, I say
I can
Sorry, my Lord, we lost out.
hello.
Hello, my Lord.
Yes, Mr.
Garba.
Garba.
Yes, my Lord.
Hey. Yes. I can. Hello,
Hello, my Lord.
Garba.
Yes, my Lord.
Yes. Hello.
Oh God. Hello, my Lord.
We can hear
I
you.
can hear you.
My Lord, we're exceptionally sorry that we lost out of the last line of my Lord's remark.
For the soft copies, they are
As
going to
God
send it
pleases.
to the copies of the judgments
As God pleases.
sent to you through the portal. Then for the hard copies, you get it of the court.
As God pleases.
So in absence of any other thing, that
My Lord,
will be all for yes.
we equally lost out release 3 and release 4 of the claimant's claims against the defendant.
Okay.
We are so sorry, my Lord.
The number one. Can you hear me?
Yes, my Lord.
Now the letter of dismissal of the claimant KSCOEA/SP
Yeah.
203 exhibit alpha
Yes.
is hereby notified and set aside.
As God pleases.
That the claimant dismissal from the service of the second defendant is void.
As God
Number
pleases.
3, that the claimant to his position, to his office and position.
As God pleases.
Number 4, the defendant directed to compute due and attributable to the claimant from the date of it.
As God pleases. As God pleases. We are grateful to the
This
wisdom of
material
God.
damages are refused.
As God pleases.
Mr. Garba.
We are most grateful to the well decision of the court.
In absence of any other thing, that will be all for and arise.
Oh, we are grateful, my Lord.
Thank you.
God, we thank you.